Okay, so this is the Daf Yomi for Thursday, March 6th, 2025. We're in Sanhedrin 79. I'm going to go to the end of 78 because we're in the middle of a Mishnah right here, and obviously the Mishnah is the most important section. So I'm going to back up to catch a paragraph or two of the Mishnah here. So it says, if one intended to kill an animal and he killed a person standing adjacent to it, or if he intended to kill a Gentile for whose murder he is not liable to be executed in court, and he killed a Jew, or if he intended to kill non-viable newborns for whose murder one is not liable, and he killed a viable person, the assailant is exempt from execution, since his intent was to kill one for whose murder he is not liable. If one intended to strike another on his loins, and the blow was not powerful enough to kill him, if it were to land on his loins, but instead the blow landed on his chest over the victim's heart, and it was powerful enough to kill him, when it landed on his chest over his heart, and the victim died as a result of the blow, the assailant is exempt from execution, as he did not intend to strike the victim a blow that would cause his death. If he intended to strike him on his chest over his heart, and the blow was powerful enough to kill him, were it to land on his chest over his heart, and instead the blow landed on his loins, and it was not powerful enough to kill him when it landed on his loins, and nevertheless the victim died, the assailant is exempt. Although the assailant intended to kill the victim, the blow was not powerful enough to kill. Ostensibly, his death was not a result of the blow. If one intended to kill an adult, and the blow was not powerful enough to kill the adult, and instead the blow landed on a minor, and the blow was powerful enough to kill the minor, and the minor died, the assailant is exempt. If one intended to kill a minor, and the blow was powerful enough to kill a minor, and the blow landed on an adult, and the blow was not powerful enough to kill the adult, nevertheless the adult died, the assailant is exempt. But if one intended to strike another on his loins, and the blow was powerful enough to kill him, were it to land on his loins, and instead the blow landed on his chest over his heart, and he died, the assailant is liable. Since in any event his intent was to kill the victim, and the blow was powerful enough to kill him wherever it struck him. If one intended to strike an adult, and the blow was powerful enough to kill the adult, and the blow landed on a minor, and he died, the assailant is liable. Rabbi Shimon says, even if one intended to kill this one and he killed that one, although he would be liable for killing either, he is exempt, because one is executed only if his action completely corresponded with his intent. And this just reflects the idea that at the time of that the Mishnah was written, or the end of the Second Temple period, the high court in Israel was more or less finding ways to exempt people from capital punishment. So that's more or less what this reflects. So the Gemara asks, with regard to which clause of the Mishnah does Rabbi Shimon disagree? If we say that he disagrees with the latter clause of the Mishnah concerning one who intended to kill an adult and killed a minor, the Mishnah should have employed the formulation, Rabbi Shimon exempts him, not the extended statement of, even if one intended to kill this one and he killed that one, he is exempt. Rather, he disagrees with the first clause in the Mishnah, which states if one intended to kill an animal and he killed a person, or if he intended to kill a Gentile and he killed a Jew, or he intended to kill a non-viable newborns and he killed a viable person, the assailant is exempt from execution, from which it may be inferred. But if one intended to kill this one and he killed that one, the assailant is liable. Rabbi Shimon disagrees and says, even if one intended to kill this one and he killed that one, he is exempt. The Gemara comments, if Reuven and Shimon were standing, and before throwing the stone or shooting the arrow, the assailant said, I intend to kill Reuven, and I do not intend to kill Shimon, it is obvious that this is the dispute between the rabbis and Rabbi Shimon. So the majority, as well as on the other side, Rabbi Shimon. If the assailant said, I intend to kill one of them, and he did not specify whether it is Reuven or Shimon, what is the halacha? Alternatively, in a case where he intended to kill one whom he thought was Reuven, and he killed him, and he was found to be Shimon, what is the ruling? The Gemara suggests, come and hear a resolution in this matter. As it is taught in a Braita that Rabbi Shimon says he is not liable unless he says, I intend to kill so-and-so, and then he kills him. The Gemara seeks to clarify the rationale underlying the opinions of the rabbis and Rabbi Shimon, and asks, what is the reason for the opinion of Rabbi Shimon? The verse states, But if there will be a man who hates his neighbor, and he lies in wait for him and rises up against him, and strikes him mortally, and he dies. Deuteronomy 19, verse 11. Based on the repeated use of pronouns in the phrase, and lies in wait for him and rises against him, Rabbi Shimon derives, one is not liable to be executed until he intends to kill specifically him, the actual victim. The Gemara asks, and the rabbis, meaning the majority, what do they derive from the repetitive pronouns in that verse? The Gemara answers, the sages of the school of Rabbi Yonai say that one derives this is to the exclusion of one who cast a stone in the midst of a group of people, and one of them is killed. Since he did not intend to kill any specific individual, he is not executed. The Gemara asks, what are the circumstances? If we saw that it is a case where there are 9 Gentiles and 1 Jew among them, there is no need for a derivation. Derive that he is exempt from the fact that there are a majority of Gentiles, and based on the majority, the probability is that the stone will strike a Gentile. Alternatively, if the group of people comprises half Gentiles and half Jews, the principle is that the ruling in a case of uncertainty with regard to cases of capital law is to be lenient, and therefore the one who threw the stone will be exempt from punishment. The Gemara explains, no, it is necessary to have the derivation only in a case where there are 9 Jews and 1 Gentile among them, as this is a case where the Gentile is a fixed presence in the group, and the principle is the legal status of any item fixed in its place is that of uncertainty that is equally balanced, and one does not follow the majority. This is what the rabbis derive from the phrase, and he lies in wait for him, Deuteronomy 19, verse 11. The Gemara asks, granted, according to the rabbis who say that if one intended to kill this individual and he killed that individual, he is liable, there is support for their opinion from that which is written, if men struggle and they hurt a pregnant woman so that her child departs from her, and there is no tragedy, he shall be punished as the husband of the woman shall impose upon him, and he shall give as the judges determine, Deuteronomy 21:22. It can be inferred from the verse that if there is a tragedy, that is, if the woman dies, there is no payment of restitution. And Rabbi Elazar says, it is with regard to a quarrel that involves the intent of each to cause the death of the other that the verse is speaking, as it is written, but if there shall be a tragedy, then you shall give a life for a life, Exodus 21:23. This is the proof that in a case where one intended to kill one individual and he killed a pregnant woman instead, he is liable to be executed, which is why he does not pay restitution. But according to Rabbi Shimon, this verse, then you shall give a life for a life, what does he do with it? According to his opinion, the party to the quarrel is exempt from the punishment of execution in this case. The Gemara answers, according to Rabbi Shimon, a life for a life is not referring to execution. Rather, the reference is to monetary restitution. And this understanding is in accordance with the opinion of Rabbi Yehuda Hanasi, as it is taught in Braita. Rabbi Yehuda Hanasi says that the phrase, quote, then you shall give a life for a life, does not mean execution, but rather monetary restitution for the life that he took. Do you say that it means monetary restitution, or does it mean only the taking of an actual life? Based on the language employed in the verse, it can be determined that the reference is to monetary payment. In these verses, a term of giving is stated below. And you shall give a life for a life, Exodus 21:23. And additionally, a term is stated of giving above. He shall be punished as the husband of the woman shall impose upon him, and he shall give as the judges determine, Exodus 21:22. Just as there, in the phrase, give as the judges determine, the reference is to monetary restitution, so too here in the phrase, give a life for a life, the reference is to monetary restitution. Rava says, that which the school of Hizkiah taught diverges from the statement of Rabbi Yehuda Hanasi and diverges from the statement of the rabbis, so the majority. The school of Hizkiah holds that in the case of where one intends to kill one individual and kill another individual, he is exempt from both liability to be executed, counter to the opinion of the rabbis, and from the obligation to pay monetary restitution. As the school of Hizkiah taught, the verse states, and he who kills an animal shall pay for it, and he who kills a man shall be put to death. Indicating, that's Leviticus 24:21, indicating that one who kills a man and one who kills an animal are comparable. This teaches that just as with regard to one who kills an animal, the Torah did not differentiate between whether he does so unwittingly or intentionally, whether he acts with intent or with no intent, or whether he strikes in the course of a downward motion or in an upward motion. This is not to exempt him from paying monetary restitution in all these cases, but rather to render him liable to pay monetary restitution, as one who kills an animal is liable in any event. Similarly, with regard to one who kills a person, do not differentiate concerning him whether he does so unwittingly or unintentionally, whether he acts with intent or with no intent, or whether he strikes in the course of a downward motion or in the course of an upward motion. And this is not to render him liable to pay monetary restitution for the damage he causes in the process of killing him, but rather to exempt him from paying monetary restitution in any event. Accordingly, it is derived from here that one who commits a transgression carrying the death penalty is exempt from paying damages for his action, even if he is not given the death penalty in practice. The Gemara asks, what is the meaning of with no intent? If we say that it means that he had no intent to kill at all and happened to kill a person, that is unwitting murder that is mentioned explicitly in the Baraita. Rather, it is obvious that the reference in the Baraita is to one who does not intend to kill this individual, but does intend to kill that individual. And it is taught, this is not to render him liable to pay monetary restitution for the damage he causes in the process of killing him, but rather to exempt him from paying monetary restitution. And if, according to the school of Chizkiah, he is liable to be executed, for what reason was it necessary to exempt him from monetary restitution? Clearly, the halacha is that one who is executed is exempt from payment. Rather, one must not conclude from it that he is neither liable to be executed nor is he liable to pay monetary restitution. With regard to liability to be executed in the case where one intended to kill one individual and killed another, the school of Chizkiah holds, in accordance with the opinion of Rabbi Shimon, that he is exempt from the death penalty and holds that he is exempt from paying monetary restitution as well. Okay, back to the Mishnah. The Mishnah says, with regard to a murderer who was intermingled with others, it is not possible to identify the murderer. All of them are exempt from liability to be executed. Rabbi Yehuda says the court gathers them into the vaulted chamber, so la kippah, where they will eventually die. Okay, with regard to all those liable to be executed with different court-imposed death penalties who became intermingled with each other, and it cannot be determined which individual was sentenced to which death, they are all sentenced to the most lenient form of execution in which any of them was sentenced. In a case where those who are liable to be stoned were intermingled with those who are liable to be burned, Rabbi Shimon says they are all sentenced to be executed by stoning, as burning is a more severe form of execution than stoning. And the rabbis say they are all sentenced to be executed by burning, as stoning is a more severe form of execution than burning. Rabbi Shimon said to the rabbis, if burning were not more severe than stoning, it would not have been administered to a priest's daughter who committed adultery. A betrothed daughter of an Israelite who committed adultery is executed by stoning. If burning were not a more severe form of execution than stoning, it would not have been administered to the daughter of a priest who committed adultery. It would presumably receive a more severe punishment. The rabbi said to Rabbi Shimon, if stoning were not more severe than burning, it would not have been the death penalty administered to a blasphemer and to an idol worshiper, as their actions violate the very core of Jewish faith. There is a parallel dispute. In a case where those who are liable to be killed by beheading were intermingled with those who are liable to be strangled, Rabbi Shimon says they are all sentenced to be beheaded with the sword, as strangulation is a more severe form of execution than beheading. And the rabbi said they are all sentenced to be executed by strangulation, as beheading is a more severe execution than strangulation. Okay, now back to the Gemara. The Gemara says that Mishnah teaches that the halacha of a murderer who was intermingled with others. The Gemara asks, who are the others with whom he was intermingled? If we say that the others are upstanding individuals, it is obvious that they are exempt. Why would they all be punished for the transgression of one who happened to be among them? And furthermore, shall Rabbi Yehuda say in that case, the court gathers them into the vaulted chamber where they will eventually die? Can innocent people be left to die in this manner? The Gemara cites a mnemonic, Beit Shin Resh Kuf, for the sages who address the above question, Rabbi Abahu citing Shmuel, Rava, and Reish Lakish. Okay, it says Rabbi Abahu says that Shmuel says, Here we are dealing with a murderer about whom witnesses testified and the judges deliberated, but this verdict was not yet finished, and he was incarcerated until the end of his trial, and he was intermingled with other murderers whose verdicts were already finalized. It cannot be determined which of them is the murderer whose verdict was not yet finalized, so that he may be brought to the court for the verdict. The reason for the dispute is the rabbis hold that a court finalizes the person's verdict only in his presence. Since the identity of the one whose verdict was not finalized is unknown, he cannot be sentenced to death. Since one of them cannot be executed, none of them can be executed. Therefore, they are all exempt. And Rabbi Yehuda holds completely exempting them is also not possible, since they are murderers. Therefore, the court gathers them into the vaulted chamber. Reish Lakish says, in the case where a person who was accused of killing another was intermingled with others, everyone agrees that they are all exempt, because one is not punished for a murder committed by others. But here it is with regard to an ox whose verdict for goring a person to death was not yet finalized, that was intermingled with other oxen whose verdict was already finalized, and they disagree. The rabbis hold that based on the juxtaposition between them, so Exodus 21:29, the halacha is that like the death of the owner, so is the death of the ox, and just as a court finalizes an individual's verdict only in his presence, the court finalizes the verdict of an ox only in its presence. Therefore, all the oxen are exempt, and Rabbi Yehuda holds that the court gathers them into the vaulted chamber. Since it is an ox that gored and the other oxen were sentenced to be stoning, they are incarcerated until they die. And then it says, Amar Rava, so Rava says. But that's the end of 79.